Good afternoon. Welcome to your North Carolina Court of Appeals. My name is Chris Dill, and I'll be presiding today. To my right is Judge Donna Stroud. To my left is Judge Jeff Carpenter. We have Eddie Sanders serving as our clerk today, and Tom Salute serving as our marshal. Thank you all for being here. We have one case on the calendar, the North Carolina State Bar versus Martin Musinguzi, and we will now hear from the appellant. And let me know if you want to reserve any time for rebuttal. Did I say the name right?
Yes, Your Honor. It's Martin Musinguzi.
Okay, good.
I'll plan on reserving 3 minutes for rebuttal. May it please the Court, Troy Shelton on behalf of the appellant, Martin Musinguzi. The question before this Court is straightforward. Can the State Bar disbar an attorney who has never been barred here? The Bar asserted this novel claim of jurisdiction over Mr. Musinguzi, even though he's not licensed here. He's not admitted pro hoc vice, and as the Bar concedes, he has a federal immigration practice that the Bar cannot regulate. There are 3 obstacles to the Bar's assertion of jurisdiction over Mr. Musinguzi, and if the Court agrees with us on any of our arguments, then the Bar lacks jurisdiction and the order below must be reversed and the case be dismissed. First, the Bar's exercise of disciplinary jurisdiction is inconsistent with Section 8428, the disciplinary jurisdiction statute. Second, the Bar's exercise of jurisdiction was foreclosed by precedent, the Frazier case from the Supreme Court of North Carolina. Finally, the Bar's jurisdiction was prohibited by its own procedural rules. I'll begin with the disciplinary jurisdiction statute. If the Court is inclined towards a textualist method of interpreting statutes, I believe this is a straightforward issue. Section 8428 of the General Statute sets out the, quote, disciplinary jurisdiction of the State Bar. Subsection A identifies who is subject to that jurisdiction. It says any attorney admitted to practice law in the state. And then subsection B clarifies who that means. It has to be either a member of the North Carolina State Bar or any attorney admitted for limited practice under the pro hoc vice statute.
Was he required to have an IOLTA account?
I don't think he was required to have a North Carolina IOLTA account, which is part of the irony of the case. I believe if he had never opened an account here, that this would never come to the Bar's attention, and then there would never have been an issue. Perhaps he could have used a New York IOLTA account, which is where he's licensed.
Or just a trust account. It could have just been just a trust and just not have the money go to the Bar.
I think that's exactly right, Your Honor. Now, the Bar's case fails under the disciplinary jurisdiction statute because it's undisputed that Mr. Musinguzi isn't an attorney who's ever been admitted to practice law in the state. He's not a member of the Bar. He's not admitted pro hoc vice. Before the issue of jurisdiction ever arose, the State Bar appeared to concede that the disciplinary jurisdiction statute controlled. The Bar cited Section 8428 in its order of discipline. That's at record page 41, paragraph 4. And in response to our arguments, the Bar doesn't seem to make any real effort to fit into the language of Section 8428. Instead, it's saying that the Bar's jurisdiction is actually controlled by a different statute, Section 8423. But that statute doesn't say anything about jurisdiction. It doesn't even use the word jurisdiction. It doesn't say who the Bar can discipline. It doesn't say what the grounds are for discipline. It doesn't say what the penalties are for discipline. All those things are found only in one statute, the disciplinary jurisdiction statute, Section 8428. In Frazier, our court actually emphasized that the Bar could not use Section 8423 and its powers there as a basis for disciplining a lawyer who had been disbarred. Neither does that statute have any textual basis for disciplining an unlicensed attorney. The Bar.
Question: do I need a North Carolina law license to appear in immigration court in Charlotte?
No, Your Honor.
Do I need a law license if somebody just walks up to me off the street and says, "I'm going to pay you"? Could you tell me what my rights are under the immigration law? I may not appear in that court, but if I accept a fee and give them advice regarding immigration law in North Carolina, and I'm in North Carolina, would that act, and I'm admitted to go practice in the immigration court, just my providing advice, would that require a North Carolina state law license if I'm not actually appearing on their behalf in the court?
It becomes a question of federal law, so I'd have to look at the particular statute that allows Mr. Musinguzi to do that. I think it would be fine, but I hesitate. I don't want to give Your Honor like an absolute answer to to that because it is a question of federal law, and I haven't looked at the statute, but he was regularly appearing. He wasn't like a transactional attorney. He was a litigator. He was appearing in front of these courts and filing paperwork with the federal tribunals.
Where would one raise a grievance in regards to misappropriation of funds from their North Carolina IOLTA account, if not the North Carolina State Bar?
Well, they could do what the North Carolina Bar did here, which they did first. They contacted the New York Bar and they said, you should discipline Mr. Musinguzi. And the New York Bar, in fact, did discipline Mr. Musinguzi. Now, I understand that the North Carolina Bar is sort of disappointed with the discipline that was administered by New York, but North Carolina doesn't get to tell New York what to do, just like we wouldn't want New York telling our bar what to do.
Not exactly the answer to the question I asked. So
Sorry.
if I understand your answer to my question is that the grieved party would contact the New York Bar in regards to misappropriated funds out of the North Carolina IOLTA account. Is that right? Is that what you're saying?
Yes, I believe that would be correct.
Why would the New York Bar care what happened with the North Carolina IOLTA account?
Well, they did discipline Mr. Musinguzi, so they do appear to care. Now, if a client was actually affected, and there are lots of other remedies that would exist for the clients. They have their own tort claims, of course. The clients here, I don't believe they were harmed, but had they been harmed, they would have their own tort claims. Of course, someone could also file a grievance with the Federal Immigration Tribunal, as the bar conceded in its brief. So there are lots of other remedies here besides the North Carolina State Bar trying to discipline Mr. Musinguzi, and I hope that is better responsive to your question.
What muddies up the water for this case is Mr. Musinguzi maintained a North Carolina IOLTA account, held himself out as a lawyer based in North Carolina representing North Carolina clients, albeit based on the record exclusively in federal court. That's the muddy part, is if it's exclusive federal, then explaining the North Carolina IOLTA account is the muddy part.
If it's helpful, Your Honor, the State Bar never relied on the fact that just because he opened up a North Carolina IOLTA account, that is the reason that they were asserting jurisdiction. And of course, it's a basic proposition of both state and federal administrative law that when on judicial review, you only look at the reasons actually given by the agency. And since the agency wasn't asserting jurisdiction merely because he was opening and using an IOLTA account, I don't think that they can properly argue that to this court.
In the opening statement of your brief, you state, can the State Bar discipline an attorney who has never been a member of the bar? The answer is no. Take it out of the federal context in light of the question that you posed in your opening statement to your brief. Say Mr. Musinguzi is say he's practicing in the state district court.
Yes, sir.
He's licensed in New York. Is the position still that the North Carolina State Bar has no authority or jurisdiction to regulate or discipline that lawyer who is practicing in state court?
So the bar does have some authority, but it is not disciplinary jurisdiction authority. So this is actually, that really is essentially what happened in the Frazier case, whereas that attorney, at the end of the case, so the first part of the discussion in Frazier talks about how the bar lacks jurisdiction over a disbarred attorney. But then it goes on to say, essentially what you're arguing, Bar, is that this attorney had engaged in the unauthorized practice of law because he wasn't licensed here. And then it goes through all of the remedies, how that works when you want to go after somebody who's engaged in unauthorized practice. And in your example, Your Honor, that would be an attorney that's engaged in the unauthorized practice of law because he doesn't have a license here and he's appearing in front of our courts. When that happens, the State Bar is allowed to go to court and they cannot internally handle it as an administrative agency because there's no jurisdictional link between the State Bar and that unlicensed attorney. So they can go and try and get an injunction that way, or what the Frazier case also says is that they can refer the matter to a district attorney for prosecution because it's also a crime to engage in the unauthorized practice of law.
What if he had been admitted pro hac vice to practice in district court and he did something bad? He's got a New York license, but he's been admitted by the North Carolina State Bar to practice. Do they have jurisdiction to discipline him then?
Yes, Your Honor. That falls under subsection B of 8420.
They could disbar him, I guess, which would mean you can't even though he just has a limited appearance kind of the pro, would that be one of the sanctions they could disbar him?
I suppose that would be a sanction. It seems more natural to me to call it revocation of
Just revocation, yeah.
But that's what it seems like to me that would be the proper remedy. But that also might sort of might be what the court would do, because it's the court that entered the order allowing him to practice pro vice. The bar has argued that A423 governs here because the disciplinary jurisdiction statute didn't appear until 1975. But I'd like to emphasize for the court that is not correct. The old statutes cited by the bar actually show the exact opposite. So if you have the bar's brief with you and you turn to the appendix that in their brief, and if you look at page 2 of the appendix, you'll see the old statutes that they cite. In particular, one that they didn't cite but is directly relevant here is on appendix page 2, section 215, subsection 11. I'm just going to read that aloud. The council or any committee of its members appointed for that purpose shall have jurisdiction to hear and determine all complaints, allegations, or charges of malpractice, corrupt or unprofessional conduct, or the violation of professional ethics made against any member of the North Carolina State Bar. That is the predecessor statute to section 8428, the disciplinary jurisdiction statute. As you can tell here, it uses the word jurisdiction and it limits that internal administrative disciplinary jurisdiction to members of the North Carolina State Bar. And if you turn to page 6, 7, and 8 of their appendix, you can see that. You can see that you see the 1970-something version of 8428 using virtually the same language. And then if you are on appendix page 8, you can look at the legislative history and see that it actually went straight from that first statute that I just read to you to 8428 when the statutes were recodified as the general statutes. So this statute has always been jurisdictional and has always limited the state bar's internal administrative jurisdiction to members of the bar. The only thing that's happened really since the 1930s is the scope of who, when the statute was amended to say you can also discipline attorneys admitted pro vice once the General Assembly enacted the pro vice statute. Now the bar's other response isn't statutory at all, but is instead relying on Rule 8.5. But the bar can't use an administrative rule to try to control its jurisdiction. Only the legislature can set the jurisdiction of an administrative agency, and this state bar is no exception. What the bar is really asking this court to do is interpret Rule 8.5 in a way that it conflicts with the disciplinary jurisdiction statute. I would ask the court to not do that, because if that happens, then it's Rule 8.5 that will be invalid, of course, not the statute. And our Supreme Court said already in both the Hart and the Rouse cases that administrative agencies cannot either expand, contract, or modify their jurisdiction through rulemaking. The agency's jurisdiction has to be set by statute because the legislature is the principal and the agency is the agent. But on its own terms, Rule 8.5 doesn't create jurisdiction for the bar. The rule says that North Carolina as a state itself has authority over lawyers practicing in the state, but the rule doesn't say that the bar has jurisdiction over these lawyers. The rule doesn't use the word jurisdiction, and it doesn't refer to the state bar or any constituent part of the state bar at all. It is at most a type of long-arm statute that says there's personal jurisdiction in favor of the state, but not subject matter jurisdiction in favor of any particular tribunal. But under the bar's theory of the law, the bar can issue its own rules that change its jurisdiction, and that is not consistent with administrative law, and it's not consistent with 8428. Rule 8.5, just like Section 8423, is not relevant to this case. The law that governs the disciplinary jurisdiction of the state bar is 8428, which uses the phrase disciplinary jurisdiction, and not even the bar argues that it satisfies the plain language of that statute. Now, our reading of the disciplinary jurisdiction statute, I believe, is confirmed by the Supreme Court's decision in Frazier. In Frazier, the bar disbarred an attorney. Years later, the bar suspected that the attorney had resumed practicing law, and so they went to discipline him again. But the Supreme Court rejected that effort, and it said that the purpose of the DHC is to discipline only those attorneys who are members of the North Carolina State Bar. The jurisdictional tie that had bound Mr. Frazier to the state bar was his license, and once he had been disbarred, he had lost his license, there no longer was a tie binding them. Now that key paragraph of Frazier is called by my friend on the other side dicta, but it's not dicta, it's the reason for the holding. It's the key paragraph of Frazier, and that reasoning makes sense because the Supreme Court was essentially quoting the disciplinary jurisdiction statute. Now, if the bar lacks jurisdiction over someone who no longer has a license, it seems to me to be a fair inference that the bar also lacks jurisdiction over somebody who's never had a license. The bar's position in this case really can't be reconciled with Frazier. That's why the bar's main argument is really that Rule 8.5 abrogated Frazier. But as I just explained to the court, an administrative rule can't change jurisdiction, so that's not possible. Rule 8.5 didn't abrogate Frazier, and Rule 8.5 doesn't refer to Frazier, which I think is really important. Judge Carpenter, you explained, I believe last year in State v. Miller, that once a statute gets a judicial interpretation, later legislation amending that statute is assumed to be consistent with the prior interpretation, unless the new legislation expressly rejects the prior judicial interpretation. I think that that's a helpful rule here because we see that Rule 8.5, when it was added, never referenced Frazier. It doesn't even address jurisdiction. Frazier remains good law, and it's an additional reason to reverse the judgment below. Now, even if the court disagrees with me on the disciplinary jurisdiction statute, about Frazier, and about Rule 8.5, we can still prevail because the bar was bound to follow its own procedural rules. Those rules don't allow the bar to discipline someone who's not a member of the state bar. I guess you could say this argument is the narrowest way for the court to resolve this case. Section 8428 of the disciplinary jurisdiction statute, subsection A says, the bar can exercise its jurisdiction, but only under such rules and procedures as the council shall adopt. But the rules adopted by the council only let them go after a member of the state bar. The rules govern the procedure to discipline members of the bar of the state, the rules say, and the rules define the word member as a member of the North Carolina State Bar. The disciplinary process begins with the filing of a grievance against the attorney, but a grievance, according to the rules, can only be filed against a member of the North Carolina State Bar. The next stage after the grievance stage is the case comes to the DHC, and a complaint is filed.
Can you file a grievance against somebody appearing pro habice from another state?
I'm sorry, say that again.
Can you file a grievance against an attorney from another state appearing pro habice?
Yes, because under the bar's rules or under the disciplinary jurisdiction statute, yes, under the statute you can. Under the bar's rules, it is not clear whether you really can. So my friend on the other side says, well, you know, it would be absurd if you couldn't do that. Well, I mean, I didn't write the rules. You know, the rules say, you know, you can only go after a member of the North Carolina State Bar. I don't believe that someone admitted here pro habice is really a member of the state bar. I think that the bar ought to admit its rules because it certainly does have statutory authority to exercise disciplinary jurisdiction over someone practicing here.
In which case, the question would be whether or not to revoke that person's pro habice, I guess.
I believe so, Your Honor.
Okay.
Yes. And so once you get to the DHC part of the process, the complaint can only be filed. You have a complaint that's filed in the DHC, but a complaint, according to the procedural rules, can only be filed against, quote, a member of the North Carolina State Bar. And once the complaint's filed, the bar's rules refer to the attorney as a defendant. A defendant is also a defined term and is defined as a member of the state bar. So even if the court disagrees with everything else I've said today, you could simply say, well, you didn't follow your own rules, State Bar, and those rules only allow the exercise of disciplinary jurisdiction over a member of the bar. And I think that there's another way of looking at these rules. To me, it's notable that these rules track the language of the disciplinary jurisdiction statute, and they track the holding of Frazier. To me, these rules reveal exactly how the State Bar viewed this situation before this particular case arose. Now, I understand that the bar has apparently changed its mind, but it has not changed its rules. Ultimately, I think that the bar focuses the most, not on the law, but on the policy. Now, policy concerns cannot overcome clear statutes, and they can't overcome precedent, just as Judge Stroud explained in the Winkler case, which held that the Plumbing and Heating Board had lacked disciplinary jurisdiction over one of its licensees. But as I discussed earlier with Judge Carpenter, I want to assure the court there's nothing crazy going on here. If the bar thinks something bad has happened, it has lots of cumulative remedies. The first was what it in fact did first, which was go to the New York State Bar and ask them to discipline Mr. Musinguzi, which it did. Second, the federal immigration courts can discipline Mr. Musinguzi, and the bar concedes as much. And last, there's tort remedies for any clients who are actually hurt. None of these clients were hurt. In fact, they benefited from what happened. So it's sort of a little surprised that those remedies weren't taken advantage of. But if there are no other questions from the court, then I think I'll reserve the remainder of my time for rebuttal.
You have about 10 minutes. Okay, thank you. Here from the State Bar.
Thank you, Your Honor. May it please the court. I'm Deputy Counsel Robert Weston here today on behalf of the North Carolina State Bar. The General Assembly created the State Bar to regulate the professional conduct of licensed lawyers for the purpose of protecting the public. The question before the court today is whether, in granting that jurisdiction, the General Assembly intended to silently exclude a pocket of lawyers, like an appellant, who live in North Carolina, practice in North Carolina, and represent North Carolinians.
One of my first questions, what act did Mr. Musinguzi do that required a North Carolina, or required a law license or permission from the State Bar, whether pro hac vice? What did he do that was considered the practice of law that would require authorization from the State Bar, either by having a license or pro hac vice? Because as I understand, he was just appearing in immigration court, which, quite frankly, doesn't even require a law license that they admit you if you get the certification or whatever. So is there any allegation he did anything that required a North Carolina bar license or at least permission from the North Carolina State Bar to perform?
Yes and no, Your Honor. No,
Okay.
Mr. Musinguzi did not require a North Carolina law license. Mr. Musinguzi's practice, is on the record.
Did he need permission from the State Bar like you would if you're out of state appearing in a North Carolina court, pro hac vice? So there was nothing he did that fell with that he needed to get authorization from the State Bar to do?
No, Your Honor, not exactly.
So if my daughter is sitting in North Carolina and steals money from her clients, can the State Bar file a complaint against her? Hey, we see that you're stealing money from your babysitting clients, so we're going to disbar you. She's not doing anything that requires a North Carolina, just because she so happens to have a license in New York. So why is that different? I mean, where's your jurisdiction come from?
Well,
You said yes and no, so what's the yes part?
Well, I'll clarify. Mr. Musinguzi does need a law license to engage in the activity he was engaging in.
Well, he need a law license to practice in Iowa, but what concern is that to the North Carolina State, because he's practicing federal court?
Certainly. His New York license did entitle him to practice in federal court in Charlotte. But I want to clarify that that doesn't mean that what he was doing was not the practice of law. Now, in the example that you gave, your daughter would not be engaged in the practice of law. She may hold a license elsewhere, but she's not practicing law here. So I don't think that implicates.
But is he practicing law? Is he practicing law that hasn't been preempted by federal? I mean, because quite frankly, what if the federal? Because the immigration court says you don't even have to have a law license. What if he was just simply certified by the immigration court to do this, and he stole money from clients? You call it the practice of law, but there's no law license required. So could you still go do something? Could you still discipline him? Because you call it the practice of law, but the federal government doesn't necessarily call it. They preempted it by saying you don't even have a law license to do this. Like if you appear for somebody at the Social Security Administration, you don't have to have a license to do that either if they certify you otherwise. So could you have disciplined him if he just did not hold a New York license, but he simply had this certification from the immigration court?
No, Your Honor. I don't think the State Bar could discipline someone that is not a lawyer for the practice.
But he'd be practicing law. You can't. You call it the practice of law because he's appearing before the immigration court on behalf of somebody. But is that the practice of law or not?
Yes, I think the immigration court would consider what Mr. Musinguzi was doing to be the practice of law. Non-lawyers can perform other functions, but Mr. Musinguzi was also taking entrusted funds from clients, presumably consulting with those clients prior to hearing. all of the things that would fall within the definition of practice of law. It's not the unauthorized practice of law in North Carolina because you can do that pursuant to federal law. That's the answer to your question you asked earlier about whether Mr. Musinguzi was engaged in the unauthorized practice of law when he consulted with clients. That's under Rule 5.5 of the Rules of Professional Conduct, which says that a lawyer can engage in the practice of law here, even without holding a North.
If I'm admitted in the Fourth Circuit and I could go up to Richmond and argue a case on behalf of my client on an appeal from North Carolina Federal District Court, could Virginia call me before their panel and disbar me?
Well, Your Honor, I don't know what Virginia's statutes or regulations on that were, so I think that would be a matter of Virginia law.
So they could assert jurisdiction if they wanted to and say, when you come to Richmond and appear in the Fourth Circuit, you are practicing law in the state of Virginia, and federalism doesn't really matter, or there's no preemption. We can discipline you because you're coming within our borders to go practice in the Fourth Circuit. They can do that. You think they could do that?
No, Your Honor.
Why can you do that if he's just appearing in a federal immigration court in Charlotte? Why does North Carolina have that jurisdiction? Why is that different?
Well, it doesn't raise the preemption issue because, as the parties have noted in their briefs, the North Carolina State Bar can't prevent Mr. Musinguzi from practicing before the federal immigration courts. So it's not a preemption issue. You can't stop that. But that doesn't mean that.
Why can't you discipline him for practicing incorrectly in that court? Can Virginia discipline me, a North Carolina attorney, for doing something wrong at the Fourth Circuit?
Well, again, that would probably depend on Virginia law, and I don't know.
You would
Well,
say,
let's assume for purposes of his question, keep his question, but assume that Virginia's law is exactly like ours.
I think that Virginia, if Virginia's laws were exactly like ours, then if you travel to Virginia and practice law before a federal court there, you would be engaged in the practice of law. You would still be subject to the regulation by the Virginia authority. That doesn't mean that the Virginia authority could prevent you from practicing, but it does mean that it could investigate your conduct, that it could make determinations about whether you had engaged in misconduct, and that it could announce those, which is what occurred here. Now,
and they could disbar me? What does that mean? Because I don't even have a Virginia license. What would that even mean? So what does that mean in this case? He doesn't even have he doesn't do anything which requires a North Carolina license. So what does it mean to disbar him?
well, disbarment has really three components in this context. The first is an adjudicatory technical component. The second is a predicate component. And the third is really a prohibitive or preventative component. The first component, the adjudicatory component, disbarment is an enumerated level of discipline. We don't have a level of discipline that is revocation. So disbarment.
If you diss something, that means they're barred. He's not barred though here. So how can you disbar someone who's not barred?
Well, disbarment in this context means that it is a level of discipline that comports with the seriousness of the conduct, and that a suspension would ordinarily not suffice for this conduct. So that's the technical adjudicative meaning of a disbarment here, is that we have looked at this conduct, we have adjudicated what happened here, and this is the level of seriousness that would merit disbarment in this state. Now, the second component I mentioned was a predicate component. It is routine for local jurisdictions to investigate and adjudicate misconduct by lawyers practicing in the federal courts before them, and the federal courts then use that as a basis for reciprocal discipline, a predicate basis. It is not correct to say that the Executive Office of Immigration Review could have held the same proceedings against Mr. Musinguzi here, because the standards of conduct aren't the same there. There's no rules in the CFR about trust accounting, for instance. So this could not have been reported to EOIR and had necessarily the same result. The bulk of what those
Was he required to have an ALTA account to practice in the immigration court? Was he required to put his client's trust money and for the interest to be for the benefit of the North Carolina State Bar if he's not practicing in North Carolina? Is he required to do that? As a New York, since he's allowed up here in group, if I'm not, and let me ask you in this way, let's say I'm not even licensed in any court, but I can practice in immigration court because they've certified me. Am I required to have an IOLTA account, first of all?
Yes, you'd be required to have an IOLTA account if you're a lawyer in North Carolina handling entrusted funds. Now, that doesn't mean he had to handle entrusted funds. Not all lawyers have trust accounts. But the obligation to have an IOLTA account comes from Rule 1.152 of the Rules of Professional Conduct. That's within our discipline and disability rules. So yes, he was required to maintain an IOLTA account if he was going to handle entrusted funds from North Carolinians. Now, the State Bar would ask that you affirm the DHC's orders disciplining Attorney Musinguzi for two reasons. First, there is a direct line of authority here, clearly, squarely on point with these circumstances, establishing the State Bar's disciplinary jurisdiction over all lawyers in North Carolina. And second, Mr. Musinguzi's interpretation to the contrary violates the canons of statutory construction and will require this court to disregard certain provisions of the statutory and regulatory rubric. Now, on that first point, I want to, at a fundamental level, note that these interpretations are not equal. On the one hand, as I said, the State Bar can point you to a direct line of authority establishing its jurisdiction and making sense of all portions of the statutory and regulatory scheme. On the other hand, Mr. Musinguzi raises a number of arguments seeking to essentially invalidate one or more of those authorities. But there is certainly nothing in the statute or regulations explicitly exempting or accepting lawyers like Mr. Musinguzi from the State Bar's jurisdiction. Mr. Musinguzi is arguing in the inferences here. So let me take you to that direct authority. North Carolina General Statute 8423 is a jurisdictional grant from the General Assembly to the State Bar. It provides that the State Bar Council is vested with the authority to regulate the professional conduct of licensed lawyers. That's a broad grant. It also becomes more specific and specifically enumerates the State Bar's ability to investigate and prosecute matters of professional conduct. And in addition to that broad grant, Section 8423 goes on to provide that the State Bar Council can do all things necessary for the furtherance of this article that are not otherwise prohibited by law. So here we have an extremely broad grant of jurisdictional power, which specifically includes the authority, the disciplinary jurisdiction. And there's no mistake that this section is a jurisdictional grant. We know that from the language that I just read you. We know that from the title of the section, which is Powers of Counsel. And we know that because the Supreme Court has held as much in the Randolph case. In that case, the Supreme Court said that the North Carolina General Assembly has vested plaintiff with control of the discipline of attorneys practicing law in this state. That includes Mr. Musinguzi, and it's cited to Section 8423. So there's no dispute that 8423 is a jurisdictional grant. Now, under that statutory grant of jurisdictional authority, the State Bar promulgated Rule 8.5. And even Mr. Musinguzi concedes that point, that Section 8423 is the authority for Rule 8.5. And under Rule 8.5, that clarifies that all lawyers in North Carolina are subject to the same disciplinary jurisdiction. And that includes the framework for effectuating that disciplinary jurisdiction that is found in Section 8428. I want to point out that Section 8428, contrary to Mr. Musinguzi's characterization, is not entitled disciplinary jurisdiction. Rule 8.5 specifically says a lawyer not admitted in North Carolina is also subject to the disciplinary authority of North Carolina if the lawyer renders or offers to render any legal services in North Carolina. It's unquestionable that that applies to Mr. Musinguzi.
You have to have a license to do that.
You have to have a license, but not necessarily a North Carolina law license.
Okay, so if the federal court in Charlotte admits me to represent people and do these legal services for these people, but I'm not licensed, which they do. I know I know you can do that with the Social Security Administration. You can be a non-licensed person and represent people for the Social Security. Could the State Bar seek an injunction or whatever, saying that's the unauthorized practice of law, because you're practicing law in the state of North Carolina and we require law license. Practice law. Why can't you do that? Isn't that preemption?
That is preemption. The Sperry case says that a jurisdiction can't stop a category of persons from appearing before a federal tribunal or require them to have a law.
So that rule of the immigration court preempts our definition of what of what the practice of law is. The practice of law, even though it's all-encompassing, cannot include doing those activities in the immigration court. It can't include. So doesn't it preempt that? So why is this the practice of law?
I don't think that's exactly right, Your Honor. I don't think that
So those activities are not preempted, do not preempt. You still say they fall within the definition.
preemption does not change the definition of the practice of law. Preemption means that North Carolina can't require that someone appearing before a court be licensed to practice law, but it doesn't necessarily change the definition of practice of law. Now, what we have then is a broad grant of statutory jurisdiction that would encompass Mr. Musinguzi. We have an administrative rule that is squarely on point and clearly encompasses Mr. Musinguzi. And if that was all there was, that would be sufficient to end the inquiry. But in addition to that, as part of this direct line of authority, we have already had the Supreme Court, because of its unique role in reviewing and approving the State Bar's rules before they become effective, we've already had the Supreme Court review Rule 8.5 and determine that it is consistent with statute. And we know that that is not simply a clerical function, as Mr. Musinguzi suggests in his brief. We know that because this court said as much in the Brewer case, and it instructed the State Bar that the Supreme Court's role in effectuating its rules, reviewing and approving them, was not simply clerical, that it was essential to those rules becoming effective. So in total then, we have a statute that grants broad jurisdiction, we have a directly applicable rule, and we have the Supreme Court having reviewed that rule and determined that it's authorized by statute. Now, in contrast to that, and that brings me to my second point, which is that in contrast to that, Mr. Musinguzi's interpretation violates the canons of statutory construction in a number of ways. I want to start before we get into that by pointing out that we directed the court to the FMSH case, and that case has a useful distillation of the principles that we follow when we engage in statutory construction. And we can really summarize those, I think, into two lodestars that we follow when we are trying to find the most reasonable interpretation of a statute. First, we adopted an interpretation that reflects the legislative purpose for the statute. And second, we adopt an interpretation, if possible, that harmonizes all of the disparate provisions and gives them independent meaning. And if the interpretation does that, then that is the most reasonable interpretation.
Don't we have to determine it's ambiguous or unclear first?
You would have to
First, we would go plain language of the statute, right?
Correct, Your Honor. And for purposes of this point, I'm really talking about Mr. Musinguzi's argument that the statute is ambiguous. And the point here, though, is that Mr. Musinguzi's interpretations do neither of those things. Mr. Musinguzi can't and doesn't really make any attempt to argue that his interpretation is somehow reflective of the legislative purpose in creating Chapter 84, which is the protection of the public. Excluding Mr. Musinguzi from regulation can't conceivably accomplish that. But I want to focus us more on the second component, which is all of the portions of the statutes and regulations that Mr. Musinguzi would require this court to leave behind. Now, Mr. Musinguzi really offers or outlines, I think, two paths to prevail. I don't think Frazier is an independent grounds to prevail on. That's, as all case law is, an interpretation of statute. So Mr. Musinguzi really has a statutory argument that by statute, the legislature has not granted the State Bar jurisdiction over out-of-state lawyers practicing in the state. And second, he has an argument that even if that pipeline of statutory jurisdiction did grant the State Bar authority to regulate out-of-state lawyers, the State Bar, by its own administrative rules, has, for some reason, capped that pipeline and declined to take all of the jurisdiction that the legislature granted it. Both of those will require this court to render some provisions mere surplusage or meaningless. I'll start with the statutory argument. I think Mr. Musinguzi's position, I think he summarized it well when he said he believes that Section 8423 has no relevance to this case. The statute that is the authority for the rule directly on point has no relevance to this case. Don't look at it. You will have to determine to conclude that Mr. Musinguzi is, to agree with Mr. Musinguzi that the statute does not give the state bar disciplinary jurisdiction. You will have to conclude that the language in Section 8423 concerning the state bar's jurisdiction to investigate and prosecute professional misconduct is mere surplusage. There's no way around it. Mr. Musinguzi doesn't have any use for that language. He calls it general surplusage. The other thing that you will have to set aside to agree with Mr. Musinguzi on his statutory argument is you'll have to disagree with the Supreme Court's determination when it approved Rule 8.5, because Rule 8.5 unequivocally provides that all lawyers in the state are subject to the same jurisdiction, and the Supreme Court reviewed and approved that as consistent with statute. So we will have to determine that the Supreme Court got that wrong. I do want to point out that there is simply no concept in law that the Chief Justice might have insincerely certified that he had reviewed and approved these regulations as consistent with statute. There's no support for that, and there's no support for that in the record.
What would you have us do with the 8423 broad grant of authority, and then the 8428 much narrower approach to jurisdiction where it limits it to members and pro hoc vici attorneys?
So I think in our brief we've kind of outlined the different purposes of the statute. I do want to clarify.
Well, so the respective sides are arguing to us that we should interpret it a certain way. So statutory interpretation general, and the more specific statute on the topic is where we look, right? We start out general and then it funnels down to the specific statute. We're talking specifically, the specific statute is 8428. It starts broad with 8423, and then as a subset of that, we're at the 8428, which is kind of where you guys are in your order.
So some portions of 8423 are very broad. The jurisdiction in general granted in 8423 is very broad, but there are specific portions of 8423 that refer directly to the ability to investigate and prosecute. So I don't want it us to labor under the belief that
right, it's investigate, prosecute. 8428, according to your colleague there, is 8428 is investigate and prosecute who? So broad, what you can do, more narrow, who you can do it to.
Right, and I think the distinction there is that 8428, what we outlined in its history, has always been the statute that clarifies how. 8423 is the who, all licensed lawyers. 8428 is how you effectuate that. And it has always contained the process for bringing disciplinary actions. It has specified the conduct that could be grounds for disciplinary action at a time when there was no rules of professional conduct. It has specified the types of discipline you could receive. It's always been the how. And that
if you read 8423 and 8428 together, now, attorney admitted to practice law in this state, subject to, along with, and it refers to licensed attorneys, why would that not be referring to the same people?
I'm sorry, Your Honor, I had trouble hearing.
If you read those together, why wouldn't that be referring to, it's like, this is giving the counsel, it's called powers of counsel, powers to do certain things, right, generally. These are powers that you have. And then 8428 is like, and these are the people who you can exercise that power upon.
Well, I think 8428 actually refers to the body of lawyers in a number of different ways, even in that section. 8428A refers to lawyers admitted in North Carolina. 8428B, I think, refers to members of the North Carolina bar and pro hoc lawyers. 8428C just refers to any lawyer can be subject to the following discipline. So the distinction there is that 8428 really isn't concerned with limiting jurisdiction. It's concerned with telling lawyers, you will comply with the rules that the state bar promulgates. It cross-references 8423 for the process of discipline. And here's the statutory framework, the bare bones of it. And the rest is fleshed out through administrative rulemaking. And then the state bar has, through rulemaking in 8.5, said all lawyers are subject to the same process. So 8423 tells us the who, what powers and over whom. 8428 tells us how that's effectuated. And that has I think we've shown consistently been the case. I don't think it's correct to say 8428 arose in 1975. I think we've outlined that that same framework of that statute existed all the way back to 1933. I also want to point out that the State Bar's position has never been that Rule 8.5 abrogated or, well, let me break this down. Our position has never been that Rule 8.5 expanded the State Bar's jurisdiction. That's not been anything we've argued. You won't find that in our materials. We also haven't argued that Rule 8.5 abrogated the Frazier decision. What the State Bar has pointed out is that the same Supreme Court that decided Frazier approved the amendments to Rule 8.5, or the Supreme Court, I should say. And that reflects our interpretation of Frazier, which is that Frazier deals with an entirely different set of facts, it deals with an entirely different set of laws, and it deals with a different set of rationale. And Frazier is about exactly what it says it's about in its first sentence, that the principal issue raised for review is whether the DHC may discipline a disbarred attorney who has allegedly engaged in the unauthorized or unlawful practice of law. The sole sentence in Frazier that Mr. Musinguzi relies on is using the term member not to distinguish between the types of people who are authorized to practice in North Carolina, the types of lawyers. It's using the term member to distinguish between someone who is a lawyer and who is not a lawyer, because those were the facts before the Frazier Court. So I do want to clarify that our position there is certainly not declaring war on Frazier, and certainly not arguing that Rule 8.5 has abrogated Frazier. Now, Mr. Musinguzi has also argued, again, that second portion of his argument, that even if the statute granted the State Bar jurisdiction, that the State Bar, for some reason, cut itself off. And Mr. Musinguzi is looking past there the definitional section where it says that the terms in this section shall apply unless context clearly indicates otherwise. And what this court would have to determine, if it agreed with Mr. Musinguzi on his administrative rule argument, is essentially that at the same time the State Bar was passing Rule 5.5, creating a standard of conduct for lawyers who are licensed elsewhere but practicing here. At the same time that the State Bar was creating Rule 8.5, clarifying that those lawyers would be subject to the same discipline in North Carolina as all other North Carolina lawyers, that the North Carolina State Bar Council was also promulgating a rule cutting off any investigatory or enforcement mechanism. That is context clearly indicating otherwise. Mr. Musinguzi would just have you render Rules 5.5 and 8.5 meaningless. They would have no meaning if that was the case.
These cases you cite in page 22, these out-of-state cases, do they all involve people, and I hadn't read them, I need to go read them, do they all involve lawyers or people that were just simply doing immigration, just like in this case? They weren't like the Colorado disbarred or Wisconsin license, that case. That lawyer wasn't practicing any kind of Colorado law. They were just appearing in the immigration court, or were they doing something else that gave it a nexus to Colorado?
I think those cases are a mixture. I think some of them are pure immigration cases. I think the Maryland D case comes to mind. I think some of those cases do involve lawyers who also engaged in practice outside of their immigration practice, and in those cases, that also resulted in...
But you think the Maryland case, for instance, that guy, whoever the respondent was just somebody that was going to federal court, going to federal immigration court, and did something wrong, and so Maryland decided to reach down and disbarred, even though he didn't have a Maryland license.
Correct, Your Honor. In some of those cases, the defendants were simply engaged in or purely engaged in federal law practice. And in those cases, there were disbarments that we pointed out. And the reason we pointed those out to you, I want to clarify this, is not to argue, it's not a prescriptive argument that the law of some other state should be the law here, or that the structure of some other state should be the structure here. It's instead to point out that disbarment does have that meaning that we talked about. It is a term of art, and it is not sufficient to simply say, well, I was never a member of the bar, so I can't be disbarred. That's not the concept that is recognized throughout the country, and these decisions reflect that all of these jurisdictions understand that disbarment means something more than simply removing someone's membership status. And the immigration courts respect that. We pointed out to you as well that the immigration courts regularly enter reciprocal discipline on decisions like these where it is an out-of-state lawyer who is disbarred or suspended.
Well, your order also says he's got to comply with that administrative code that says he's got to notify all his clients by certified mail. Can you make him do that if he doesn't have any clients for which requires a North Carolina license? I mean, is he subject to that sanction as well, or can you just say, you're disbarred, you can't practice here? Can you make him do something like that?
Are you talking about the portion of North Carolina's discipline and
And it's
rules?
part of the order. You
Okay.
shall comply with, I think it's 127. I think that's the one that says
I know.
obligations of disbarred attorneys. You have to go do these positive things. Go contact all your clients and tell them that we did this to you. Can you make them do that?
Well, Your Honor, I think in the Rule 60 order that came down, the court clarified that portion of its order directing compliance with 127 was limited to any portion of his practice that may be outside of the federal immigration practice.
Okay, I got you. Okay, so they did that. Okay.
So it's narrowed, it's clarified that. Your Honor, I see that my time is expiring. For the reasons stated today and in our brief, the State Bar respectfully requests that you affirm the Disciplinary Hearing Commission's orders disciplining Attorney Martin Musinguzi.
Hold on a second. It seems to me your position is that your connection or your nexus is he submitted to the IOLTA account, therefore he submitted to the IOLTA trust rules and the rules of professional conduct under North Carolina. I think that's your best approach to the nexus that you need. Is that right?
No, Your Honor, I don't think exactly that. I think that is an important indication that all parties here once interpreted the statute the same way, but I don't think that, as we pointed out, that Mr. Musinguzi could have stipulated to subject matter jurisdiction here.
Agreed. You can never stipulate to subject matter jurisdiction. Maybe I just asked the question inartfully or unintelligible.
Well, I apologize if I didn't understand it, but I would agree that he was required to maintain an IOLTA account. That's part of the discipline and disability rules.
Once he opens an IOLTA account, he's got to comply with the North Carolina IOLTA account rules, correct? If it's not an IOLTA account, he doesn't have to comply. But if it's an IOLTA account, he does. Is that not correct?
Well, the trust accounting rules are in the rules of professional conduct. They outline the way the lawyer must manage the trust account. There are separate rules in, I think, subchapter 1D for the standing committees of the State Bar about what an IOLTA account needs to be in terms of the laws of the state it needs to be organized under, whether that's North Carolina or federal, et cetera. So you would have to comply with those two.
Right. IOLTA is interest on lawyers' trust accounts. Basically, the bank's taking the interest that the trust account earns and turns it over to the State Bar.
To a fund, correct.
We don't have to get technical. That's what it stands for. That's the name of it. It seems to me that your position is if he set up this account in North Carolina under IOLTA, whereby he agreed that his trust account interest would be turned over to the State Bar, then he must comply with the rules under the trust accounting system for the State Bar. Is that not, am I off base there?
Well, I do agree that he has to comply with the rules, the trust accounting rules. Yes, Your Honor.
Okay. I'm done.
Thank you.
Mr. Shelton, rebuttal?
Thank you, Your Honor. I will pick up where we left off. As Judge Carpenter was asking, was there jurisdiction based on the IOLTA account? I mentioned in my response earlier that the State Bar can't now suddenly rely on the IOLTA account as the basis for asserting jurisdiction, because under administrative law principles, an agency cannot argue alternative bases for affirmance. Just wanted to provide the court a citation for that. One of the most recent cases is Frazier versus Town of Blowing Rock, which is 286 NC App 570. That was an opinion by Judge Carpenter for this court. When it comes to statutory interpretation in this case, I think I heard my friend on the other side suggest that we suggested that 8428 is ambiguous. Our position is that 8428 is actually quite clear. The bar has never argued that there's anything ambiguous about any word in that statute. It's undisputed that a member of the State Bar means a member of the State Bar, And so we're just asking this court to apply the statute's plain language.
So is your language, I mean, is your argument purely just statutory interpretation? Because the question I have, and maybe you didn't make this argument, could the General Assembly give the state bar authority to regulate how your client conducts himself in a federal immigration court? Or is that's not, you're not arguing a preemption argument?
We're not making a preemption argument. I think they could regulate him to the extent it's not preempted. So I don't know if there's a field we have not done like a full, whether there's field preemption analysis or anything like that. I think that there's perhaps some practice, some parts of his practice that maybe wouldn't be preempted. I don't have a position on that, for your honor, today. Now, we did concede that the state bar cited Section 8423 when it adopted Rule 8.5. But that's not because 8423 is a jurisdictional statute. The bar cited 8423 because it always cites 8423 when it adopts rules, because its rulemaking authority comes from Section 8423. It says that statute says that the bar has the power to formulate and adopt rules of professional ethics and conduct. That's all we meant when we said, well, that's the only thing they cited. We know that 8423 can't be a jurisdictional statute because it doesn't mention jurisdiction anywhere. Only 8428 does that, and it's done that for almost 100 years now. And if we were to look just at 8423, the broader statute, as Judge Carpenter was alluding to, it's not even geographically limited to North Carolina. It would say that the bar could regulate any attorney anywhere. I mean, even in another country. I mean, there's just no geographic limit. It doesn't at all answer the who question, which only 8428 answers. And so I think for that reason, Judge Carpenter, I think you hit the nail on the head when you said, well, 8423 is a broad grant of authority, true, but in 8428 is the narrower statute that addresses the narrower issue of, quote, disciplinary jurisdiction. If 8428 doesn't apply to Mr. Musinguzi, then there really is no statute telling the bar what they're supposed to do with Mr. Musinguzi. It's only 8428, if you'll recall, isn't just about the who. Subsection A and part of subsection B is, but the other part of subsection B and subsection C says, well, these are the grounds for the discipline, and these are the available sanctions that you can apply. But if 8428 doesn't apply to Mr. Musinguzi, we have no idea. There is really no statute that says what they could do to Mr. Musinguzi.
So you're saying that the General Assembly could have given the state bar authority, but they just didn't?
That's right.
Okay.
I think that's right. It's subject to our preemption discussion earlier, yes, I think that's correct. And Chief Judge Schilling, you asked earlier, what was the point of this disbarment? And my friend on the other side seemed to say, well, it's like a token legal recognition that what he did was really bad. But that sort of strikes me as circular reasoning. It doesn't really say, well, what is the result and like real world effect of disbarment for someone? So in the out-of-state cases that my friend on the other side cites, they don't actually engage with that question either, as far as my recollection of what does it mean to disbar someone who's not barred here. So I think if the court were to decide, well, disbarment just can't have a legal effect, then the result would be, again, that there'd be a lack of jurisdiction, but this time because the bar just issued an advisory opinion. Now, I think that in some ways we're really talking about a narrow issue in this case. I don't think that there are a lot of attorneys that fall into this bucket like Mr. Musinguzi falls into. I think we're mostly talking about attorneys who are not licensed here, but somehow allowed to practice here, like in this case where federal law allows them to practice, even if North Carolina wouldn't. And I think everyone else outside of that bucket, most of those attorneys would be engaging in the unauthorized practice of law. But of course, that's not true for Mr. Musinguzi, and the state bar's never accused him of engaging in the unauthorized practice of law. So I think that there are a lot of different ways to think about this case. You can think about it as a case about textualism and statutory interpretation. Are we going to follow the plain text of really an unambiguous statute? You can say this. You can think about this case as a case about administrative law. We're going to let agencies try to add to or change their own jurisdiction through rulemaking. But I think that really no matter how you think about this case, the result should be the same. The DHC and the state bar lacked disciplinary jurisdiction over Mr. Musinguzi. And if there are no other questions, we'd respectfully ask that this court reverse the order of the DHC and order that this case be dismissed for lack of jurisdiction.
So the jurisdiction argument you may have been in a better position to make it more timely with the response to the State Bar's complaint that they sent out instead of getting defaulted.
That's true, Your Honor, though I think that I think it's undisputed that we were allowed to raise it through Rule 55 and rules.
True, but it sort of signals that you don't have jurisdiction, so I don't have to bother to respond to you. And which ends you up here.
I agree that it would have been better to raise this argument at the beginning. I think Mr. Musinguzi wishes that he had participated likely in the DHC proceeding, but those are not the facts of this case, and we can't go back in time. And so here we are. If there are no other questions, I'd ask that you reverse and dismiss. Thank you.
Thank you for your arguments. We will take it under advisement, and we'll adjourn court.
The things I think I saw you in the Zoom with DHC.